This case, originally filed as Newdow vs. United States Congress and Elk Grove Unified School District in 2000. Michael Newdow, who was a non-practicing lawyer and practicing doctor, sued the Elk Grove Unified School District because his daughter had to recite the pledge each morning, which contained the words, "Under God." This was argued to imply that the nation had a belief in the existence of a God, which Newdow, an atheist, argued interfered with his rights and ability to raise his child. He also argued that it violated the Establishment Clause because the clause states, "Congress shall make no law respecting an establishment of religion," and by lawfully adding "under God" to the pledge, Congress had implied or established that America was a nation which believed in God or a God. District Court ruled that the pledge was constitutional. Newdow appealed the school district and took the case to the Ninth Circuit. In June 2002, the ruling by the United States Court of Appeals for the Ninth District that the words "under God" in the Pledge of Allegiance are an endorsement of religion and therefore violate the Establishment Clause. In December of 2002, Sandra Banning, the mother of Newdow's child, filed a motion to intervene or to dismiss Newdow's complaint. She declared that although Newdow and her shared legal custody of their child, a California court order granted her exclusive legal custody of the child, including the sole right to represent her legal interests and make all decisions about her education and welfare. The court held that under California law, Newdow retained the right to expose his child to his particular religious views, even if those views contradicted the mother's, and that Banning's objections as sole legal custodian did not defeat Newdow's right to seek redress for an alleged injury to his own parental interests. The Supreme Court decided to take the case Elk Grove Unified School District vs. Newdow on March 24, 2004. The Supreme Court accepted the case due to prior disagreement. On June 14, 2004, the Supreme Court ruled that Michael Newdow, as a non-custodial parent, did not have standing to bring the suit on his daughter's behalf. So the Supreme Court never issued an official opinion on the constitutionality of the pledge due to the fact that Newdow did not have proper grounds to argue the case, thus voiding the legitimacy of all prior rulings.
The constitutionality of the Pledge of Allegiance was defended by Solicitor General Theodore B. Olson and Terrence J. Cassidy of the Elk Grove Unified School District of California. The plaintiff in this case was Michael Newdow, who is a non-practicing lawyer who had a child with Sandra Banning. The two of them were not married, and so Sandra had full custody of the child. Lemon v. Kutzman was a related case in which a private elementary school in Pennsylvania had been overstepping the limits of the Establishment Clause. Their actions had allowed the superintendent of public schools to reimburse private schools for the salaries of teachers who taught in these private schools from public textbooks and with public instructional materials. This case also established the Lemon Test, which details the requirements for legislation concerning religion. The test states that a statute must not result in an excessive government entanglement with religious affairs, also known as the entanglement prong. The second part of the Lemon Test states that the statute must not advance or inhibit religious practices, also known as the effect prong. And the third part states that the statute must have a secular legislative purpose, also known as the purpose prong. We believe that the Supreme Court made the proper decision by dismissing the case because law states that in order to file a lawsuit on behalf of a minor, the person filing the lawsuit must have full custody of the minor, In this case, Newdow did not have full custody of his daughter and therefore did not have proper standing to file such a lawsuit. The impact of this case was that the ruling clarified who can file a lawsuit as a next friend. The suit established that in order to file a lawsuit on behalf of a minor, you must have full custody of that child. In this case, Newdow did not have full custody, which is why the Supreme Court dismissed the case. We believe that this case will be revisited because there was never an official ruling on the constitutionality of the Pledge of Allegiance. 3 of the justices did publish opinions concerning the constitutionality of the Pledge of Allegiance, but there was never an official court decision.